with the California Supreme Court, the federal habeas petitions with a U.S. District Court and a Ninth Circuit Court of Appeals. In all those situations, as you will hear, the Menendezes have raised many of the same exact arguments that they raised in the current habeas petition. Those arguments have been heard by a variety of courts, from the trial judge to the direct appeal Court of Appeals in California Supreme Court, to the California Supreme Court again, to the federal courts. They've considered these arguments, and they have been routinely and repeatedly rejected. So we have the video that is coming out and go through this procedural history so that people can actually learn from the Menendez case and help and actually educate themselves on the criminal justice system. What I've said very often is if the Menendez case is the portal by which people come into the criminal justice system and show an interest in it to find out what's happening, then hopefully they will educate them further about what happened not just in the Menendez case, but criminal cases that are occurring throughout this entire county, this state, and this country every single day. So the video is coming out today, and it'll be out on our website. The second thing that we have done today is that we have filed an informal response in connection with the habeas motion. As I mentioned before, there are these three parallel tracks: the habeas, the clemency, the resentencing. Again, the clemency is up to the governor. Resentencing we will be dealing with in the future, in the next coming weeks, with our response. But today we have filed the informal response on the habeas petition. Now, something you need to know about a habeas petition: it's not the direct appeal. The Menendezes have already had their direct appeal through the California Court of Appeals and California Supreme Court, and they have lost. They've even had one level of California habeas, which they lost, and one level of federal habeas, which they've also lost. So now they've come back for a second California habeas petition. And in coming back for that, they have basically said there are two new pieces of evidence, along with their arguments, that justify them getting a new trial. Now, in a habeas petition, there are very rigorous requirements to actually get that new trial, which makes sense, because you've already gone through all these different layers of review. And if you've been rejected time and time again, at some point the system says that unless you have something very new and very compelling that is more likely to change the outcome of this case, then we are going to again reject your habeas petition. So when they come out in this case, they come out with two new pieces of evidence. One piece being an undated photocopy of a letter purportedly sent by Eric Menendez to his cousin Andy Cano at approximately December 1988, although there's no date on the letter, in which it discusses sexual abuse that was being experienced by Eric, perpetrated against him by his father at that time. That's the one piece of evidence that they've come forward, but they also came forward with a second piece of allegedly new evidence. The second piece of new evidence was a declaration by Roy Rossello, who basically said that in the early 1980s, he had been sexually abused by Jose Menendez. But the standard to actually have a successful habeas petition requires that you meet all of the following requirements. You have to show that it's new evidence. You have to show that it's timely, that it was evidence that could not be discovered at the time of the trial, but only could be discovered after the trial. You have to show that you did not engage in any substantial delay between the time you learned about the evidence and the time you brought your motion. The evidence has to be admissible, and the evidence has to be credible. Now, the overall argument about this new evidence, again, new evidence effectively dealing with sexual abuse that Eric Menendez experienced by his father, or a gentleman named Roy Rossello experienced by Jose Menendez, the defense has now argued the following. They've said to resolve this case, jurors had to decide a single critical question: was Jose Menendez molesting his sons? The problem with saying that that is the critical question in the Menendez trial is that it's wrong. The jury never, in any of the two juries, had to resolve the question of whether the Menendez brothers were sexually molested. In fact, the counsel, Leslie Abrahamson, 30 years before, during these trials, properly framed where sexual abuse comes into play. What she said back then is that we have never said that because you're abused, you're justified in killing your abuser. We didn't argue that, and we never will. Well, 30 years later, apparently, the Menendez counsel is arguing just that. Because what the jury had to figure out is on the night of August 20th, 1989, did the Menendezes conspire to kill both their father and their mother that night? Did they in fact kill them? And what was their state of mind at that time on the night of August 20th, 1989? Did they engage in these killings willfully, deliberately, and with premeditation, or was it an act of self-defense? They had an actual fear of imminent harm, that both their father and their mother was going to kill them, and they acted in self-defense. The sexual abuse part, as Leslie Abrahamson recognized correctly back then, was not a fourth question for the jury to answer. So when we look now at the factors dealing with this new evidence, we can go through these factors. Timely evidence that is discovered after the trial for which there is no substantial delay in presenting it. Well, if this letter, supposedly dated December 1988, written by Eric Menendez to Andy Cano, is to be believed, and that it was actually sent at that time, here's what we know. We know that Eric Menendez, during his second trial, testified for 7 days about graphic descriptions of the sexual abuse that he had encountered by his father between the ages of 6 and 18. He also talked about sexual abuse that his brother Lyle had experienced by his father between the ages of 6 and 8. That evidence was brought in, and he was asked about who he spoke to about this sexual abuse during that time period. He said he had spoken to Andy Cano. When did he speak to Andy Cano? He said when he was between the ages of 12 and 13, and Andy Cano was approximately 10 years old. That was before Eric Menendez moved from New Jersey to California, roughly 6 years before these 1989 killings. So Andy Cano also testified in the trial. And Andy Cano relayed the same information, that he had had this conversation with Eric Menendez 6 years before the 1989 killings when he was 10 and Eric Menendez was either 12 or 13. They spoke several times that year, and that was the only conversations they had about the sexual abuse, only communications they had. So now we have a letter filed in May of 2023. That is supposedly a 1988 letter written from Eric Menendez to Andy Cano about this sexual abuse, never discussed in any of the two trials when Eric Menendez testified or Andy Cano testified. And we believe it's inconceivable, as we've argued in our papers, and defies common sense, that if they had evidence that would show that sexual abuse had been communicated not just 6 years before the events, but 9 months before the 1989 killings, that it would absolutely have come out during one or both of their testimonies. So the fact that it didn't come out, again, goes to whether or not this evidence first was discovered after the trial. If Eric Menendez wrote this letter, he had it or knew about it, or Andy Cano had it and certainly knew about it by the time of the 1993 trials. In fact, it's a 1988 letter. They would certainly have it by the time of the 1995 trials. So to say that this letter was not discovered after the trial, as it's been alleged in the defense papers, we believe is just wrong. The second thing with this letter is that if the letter was real, then the question is, when is the substantial delay triggered in actually filing this motion? So So what you find in the motion is Eric Menendez is saying, I didn't know about the letter until effectively a 2015 special by Barbara Walters, where this letter had been given to her.
All right, you've been listening to LA County DA Nathan Hochman laying his case out for hearing the appeal of the Menendez brothers. The Menendez brothers looking to be released from prison. We've been following this for quite some time now. This is a big decision, and obviously the LA County District Attorney wants to lay out every single reason why he's going to make the decision he's going to make. So we're going to continue monitoring this, and we're going to come back to it. It does certainly seem like he is leaning in the direction of going against the brothers' appeal, but we'll see what he says. He's laying out his case right now. In the meantime, we're going to turn to some other news, and we'll get back to Matt Gutman, who's in that room for us when the decision is made. We're going to turn to other news, and the latest on the Trump administration right now. The president is expected to sign new executive orders any moment now as the list of laid-off federal workers continues to grow. President Trump promises more job cuts. Elon Musk leading the DOGE efforts to downsize the government. And the Washington Post reports Trump is preparing to dissolve the leadership of the U.S. Postal Service and absorb the independent mail agency into his administration. A raucous crowd of constituents expressing their frustration and anger with the Trump administration during a town hall in Georgia. Congressman Rich McCormick was interrupted several times as he tried to defend the president during yesterday's meeting. Listen to this.
But by and large, the president has great purview over where a lot of this money goes. Now, some of this is going to be litigated. I'll pause whenever you want, and you can go and yell all you want, but I can't understand 10 people, let alone 100 people at once.
Joining me now for more is ABC News senior White House correspondent Selena Wang and investigative reporter Olivia Rubin. Selena, I want to begin with you. What's the latest on the mass layoffs from DOGE, and what are you hearing from federal workers about all these layoffs?